Hi, my name is Akiva Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. Today we're continuing our video series designed to educate the public, so please subscribe to our channel. Often the threat is made by one spouse to another in a divorce. Things are going bad. Parties are warring, screaming, a lot of drama. Somebody says, I'll kick you out of the house. The question becomes, can one spouse legally kick another spouse out of the house? Well, the short answer is no. The short answer is no, because the only one who legally can tell somebody to leave a house is a judge. The judge has the right to grant someone exclusive possession of the marital home. During a divorce, one can ask the court for permission to have exclusive use of the marital home, which in effect kicks the other person out of the house. But notice a couple things. Number one, it's the judge making that rule. And number two, you got to ask permission. You got to file a motion. The court may say yes, the court may say no. In most cases, the court's not going to have exclusive possession by one as opposed to the other unless there's a very, very strong, compelling reason to kick someone out. The fact that the parties don't get along, that's not going to cut it. You're already getting divorced. We already know you don't get along, right? That's not going to be a reason to kick someone out of the marital home. Remember, the marital home, at least on its face at this time, belongs to both parties. So when you kick someone out of the house, you're kicking them out of what is essentially their own house. Before the court does that extraordinary thing, the court's going to have to be persuaded that there's a compelling reason to do so. Around here, most courts, they are not going to grant exclusive use of the marital home unless a couple things have happened. So I'll tell you instances where we've seen it. For example, in a case where there's profound spousal abuse, okay? Somebody's beating the crap out of somebody else, the court's not going to allow that. The court's going to remove that person from the marital home, okay? That's one thing. There may also be a personal protection order or a no contact order from domestic violence case or something like that that could cause a person to be removed from the marital home. Another possibility why the court might say that somebody should be removed from the marital home, let's say they're already gone. Let's say during the divorce somebody has moved out and taken an apartment somewhere. Well, in that case, the court can order that one person have the marital home and the other person stay there, and it kind of makes sense because even though the home does belong to both parties, even if one party moves out, there's no abandonment of the property, so it still belongs to both. But the court can say, look, this person's already moved out. She can have exclusive use of the house and change the locks. She doesn't want to come in one day and find him rummaging through the house. That's not right. Also, when somebody moves out, who knows who else might get access to the keys and come to the house. The person doesn't feel safe, they get exclusive use of the home. And exclusive use usually means they can change the locks, put an alarm on, make sure that they feel secure. And the court will normally allow that in that scenario. But remember one thing, absent those compelling facts, it is more likely than not that the court is going to say, I'm not ready to rule on who gets what at this early stage, therefore the home belongs to both, therefore they both get to stay. If you have any questions about that, reach out. We'll be glad to help you out.